Okay, so in this video, we're going to go over an actual will versus living trust analysis and decision. I'm Paul Rabelais. I'm an estate planning attorney. I help our estate planning law clients get and keep their legal affairs in order. And from time to time, I share just in general some client experiences, some client conversations. Of course, got to keep all the names confidential to protect the innocent, as they say on TV. But there's no better way to maybe teach some of this stuff than to share with you some actual experiences and to share with you what clients hear and say as they go through the process. So I had a client yesterday come in and their financial advisor gave them my name about a year ago, and finally they got around to giving my office a call. They came in and they were an older couple, maybe their late 70s, maybe for some that's not older. And they had, I don't remember exactly how many, 2 or 3 children, and they just wanted to get all of their legal affairs in order. They didn't have any kind of crazy family or any unique family circumstances. They just wanted it all in order because they knew that they needed to get in order, and they had never done any kind of estate legal planning before. So, we went through the usual discussion of, when you pass away, do you want it to go, anywhere other than your children equally, and who's going to be involved in, that distribution, and, selling the house when they pass away, handling the investments. And they have kind of the usual assets, IRA, Roth IRA, brokerage accounts, home, vehicles. And so we went through those decisions on who's going to handle things, how things will go. It was all going good. And then it gets to the point in the conversation where we typically have this will or trust conversation, because I like to give people the opportunity to choose which method they want to use to leave things to each other and to their children. And for some, they choose let's do it through our wills. Let's leave everything in our name. Yes, when each one of us dies, there's going to be a probate process when we die. Or some people choose, no, let's set up the living trust and retitle assets in our trust, so those 2 probates, or as we call it in Louisiana, successions, are not going to be necessary. The court and lawyer involvement won't be necessary. So, and I find that people make the decision on which one is best for them based on their past experience. Things like what happened when their parents died. It plays a big factor in how people make decisions on how and the method and how they want to leave things when they pass away. Some people say, back when my dad 40 years ago, when he set things up, he named both of us on his power of attorney, and then this happened and that happened, and based on what happened when we tried to use our father's power of attorney, this is how we want to do it moving forward. And we see a lot of that come into play in the old will versus living trust analysis or decision. So it happened that the husband was the executor of his mother's will, and she died back in, I think it was 1992. And for some reason, they brought in this big legal size envelope full of all the probate documents back from when she died in 1992. So we were going through what do you think is best, the will and the probates, or the living trust and titling things that way now, and avoiding the probates? And the wife pulled out all of those probate documents where her husband was the executor and her husband's mother had passed away around 1992. And she started glancing through all those probate documents. They were kind of yellow, but all the normal stuff. And she noticed a couple things. She noticed that that all of the deceased's, her mother-in-law's assets were itemized out on all of the inventories. She noticed that the attorney's fees listed in the inventory of assets were about $5,000 back in 1992. And then she noticed one other thing. She noticed that I believe the woman died in April of 1992, and she noticed that the judge that was assigned to the probate proceeding signed the what's called the judgment of possession, or the court order ordering financial institutions to transfer assets to the heirs. That was signed 11 months after her mother-in-law had passed away. So when she looked at that, those three things kind of bothered her. One was, I don't want my kids to have to get all this stuff to lawyers and inventory everything we have. I see back in 1992, while my mother-in-law didn't have a whole lot, the attorney's fees were $5,000, and that's in 1992 dollars. And I could tell going through her mind, she's like, well, $5,000 in 1992, that's like maybe $8,000 or $10,000 today. And then she really didn't like that the judge signed the court order 11 months after her mother-in-law had passed away. And that signature on that court order just is the starting point for getting the assets transferred to the heirs. Then we have to take that court order, go to the financial institutions, and divvy things up. So based on what she saw that her family had experienced 20 years ago, it really kind of made it easy for her and her husband to look at each other and say, it would be easier if our family doesn't have to go through this, and we can set things up where those two probates, one when each of us would die, is unnecessary. So then they chose the trust route because of what they saw that the family had experienced really almost 20 years ago, and that was maybe the driving factor behind what they wanted to do. So anyway, just going to keep sharing some of these general client experiences. Another secret that I'm going to share with you to really make it simple to get all of your legal affairs in order. The secret, probably shouldn't tell anybody this, but the secret is make sure you punch the subscribe button and the notification bell so you don't miss anything. And then the YouTube algorithms love the thumbs up. So if you can do that, we'd really please the YouTube algorithms. And then stay tuned every 10 a.m. Central Time, every morning, more estate planning, educational videos. I'm Paul Rabelais. Make sure you've got things in order. We'll see you tomorrow.